Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here each and every week at this time on this station to bring you, the Pennsylvania landowner, the information that you need regarding natural gas development. And of course, and as always, I, Doug Clark, the Clark Law Firm, have not, will not ever represent gas or pipeline companies. They have enough lawyers. I'm here to fight for you, the Pennsylvania landowner, royalty owner, gas right owner. We need to level this playing field. We need to get this information out to you, and we need to stop people being taken advantage of routinely. We need to stop it, and that's what we're trying to do. So keep tuning in each and every week for All Things Marcellus. I represent landowners for any and all issues related to natural gas development, including, but not limited to, gas lease negotiations, gas lease reviews and consultations, litigation regarding gas lease issues. Did your lease terminate? Has the company breached your lease? Royalty and royalty deduction issues. Have you been charged deductions when you shouldn't have? A real big area today that I'm dealing with constantly is when companies are seeking to develop properties with very old leases. When I say very old, sometimes literally into the 1800s, early 1900s, but I also mean, when I say old, I also mean 2000 to 2005 and 6, that those leases many times, I can't state this enough, if you have a lease that predates, say, 2006 or before, and especially in the area of the early 2000s, that you, if you've not received a royalty check and you're receiving shut-in checks or you're receiving these yearly checks to hold your lease, you may have a claim that your lease is actually terminated. And it's very important, if you think that is the case, that you, okay, again, this is not specific advice, but generally speaking, it is important not to cash those checks if you think there's a breach. And before you cash those checks, you should go have a review, consultation, consult with an attorney who knows what they're doing to give you an opinion as to the status of your lease. And then also, a red flag, not just one, the biggest flag, and many of them, should be popping up everywhere. If you have an older lease and the company gives you a lease, either lease modification, ratification, amendment, or it gives you a modification and ratification, they're all in the same document, or just provides you and asks you to sign a document with the word ratification in it. Ratification, saying we want you to ratify and agree that your lease is valid. Why do they want you to do that? Well, maybe your lease isn't valid. And by ratifying it, you may be, in a stroke of a pen, eliminating all kinds of arguments, or in fact, reviving a lease that is otherwise terminated. Just by merely signing this ratification, literally people can be losing hundreds and hundreds of thousands and literally millions of dollars. Ratification. Please, if you're asked to sign those, get help. There may be a major issue. You can't just go sign. You can, but you shouldn't go signing those without getting at least a review and consultation. Remember, when a company asks to ratify your old lease, call somebody, put the pen down, call. Put down the pen, pick up the phone. Ratifications are a big deal in many cases. Don't get fooled. Anytime you're putting ink to paper, it may be a really big deal. And that's why I say reviews and consultations are so valuable. Take an hour or two, and you find out before you sign if you're signing something or about to sign something where you're making a big mistake. So I implore you, if you call me, wonderful. I'd love to hear from everybody who I can talk to and who I can represent. But if you don't call me, please, I encourage you to call somebody who knows what they're doing before you sign these agreements. It's only to protect you, your property, your children, your grandchildren. The companies have enough money. We need to make sure that you're doing the best you can. And if your lease is expired, you should have a new lease, not ratify an old lease that's going to pay you 12.5% royalty, which is the minimum royalty allowed by law. 12.5%, 1/8 royalty equals 12.5%. Ladies and gentlemen, you cannot do worse. That is the lowest royalty percentage allowed by law. And you could now be locking in the lowest royalty percentage allowed by law, and a good chance also including the maximum deductions or reductions from your royalties for post-production costs. So you may have the lowest royalty percentage and the maximum deductions allowed by law, and you sign a ratification to essentially say, yeah, it's okay, I'll continue to live under that contract, when you may be entitled to a new lease. That contract may have expired. They're not going to tell you that, guys. You need to get information for somebody working for you. So if you have 100 acres and you sign a ratification and you're stuck now, you get no bonus. You're going to get a same royalty percentage, lowest allowed by law, and full deductions, and you just signed a ratification to lock it in, and you may be an area in southwestern Pennsylvania, $4,000 or $5,000 an acre. 18% royalty. So if you had 100 acres, you might have just literally given up $400,000, $500,000 instantly, then gave up an additional 3%, 4%, 5% royalty, 5.5% possibly, for the lifetime of the lease. We can't, I hope this is clear. We got to stop doing that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can always call, learn about the reviews and consultations, 570-307-0702, 570-307-0702. And keep listening to All Things Marcellus each and every week at this time on this station. We're going to keep giving you this information. We want to raise the bar for everybody in Pennsylvania. Quick reminder, if you can't join every week at this time on this station, you can go to our websites. I have 2 websites. I'm a little biased since I wrote almost all the material on the websites. You can go to pagasleaseattorney.com, pagasleaseattorney.com, and pipelineattorney.com. I believe they're very good websites and very informative. Whether you're looking for representation, you want to learn more about me and what I do, or you want some just general information to raise your intelligence in this area, go to the websites. Also, one other bonus I started to say, if you can't join each and every week at this time on this station, you can go to pagasleaseattorney.com. You can go to pipelineattorney.com, and today's radio show will be up and available Monday morning. There are, and I don't think I've said this in a while, but in case you didn't know this, I, Doug Clark, have been doing this radio show, All Things Marcellus, since 2010. Been doing the weekly radio show, All Things Marcellus, since 2010. So there's a lot of hours. Now, we don't have them all back to 2010 up on the websites, but there are many hours of shows covering all kinds of topics. So if you're new to the show, go check out the websites. You can listen to other shows at your convenience. If you can't join each and every weekend when we're doing the show, then you can go check it out during the week. pagasleaseattorney.com, pipelineattorney.com, and of course every week at this time on this station. So I said one of the websites is pipelineattorney.com. Well, ladies and gentlemen, and I know I may get a little fired up because I love/hate this topic. I love it because it is an outstanding example to show people what we can do to make this situation a better situation for the landowner. I hate it because companies present such terrible one-sided pipeline agreements to landowners that landowners are just, and many landowners are just signing them. And it drives me crazy, in my opinion, to see people being taken advantage of because of the lack of information that they have and not understanding the documents that they're signing and what these documents mean. They also, people who just sign, will tend to rely on the company, pipeline company, landman, who, as we all know, works for the company and not you. Ask for their business card. Your name isn't on it. They're working for the company, and their goal is to get your signature on the pipeline right-of-way agreement. So we're going to talk about pipeline right-of-way agreements, and I'm really going to focus in today on one of my sarcastic favorite players in the industry, and that being Sweppy LP. Sweppy LP, who is in Tioga County. Mostly, that's where most of their activity is. And here's something I want to start off with. We'll set the stage here, this first segment, and then I'm going to get into this agreement. And remember, although this is a Sweppy LP agreement, I do not care where you are in the Commonwealth of Pennsylvania. The same principles apply. I'm going to go through this form agreement that they present to people, but any agreement presented by any company is going to have similarities and the loopholes that I am going to discuss that are designed specifically to benefit the company. These same loopholes exist in many other agreements. Remember, I have negotiated on, reviewed, consulted on pipeline agreements in Pennsylvania with over 70 different companies. 70. So I'm just going to say I have a lot, and I hope this comes off good. I have a lot of experience in pipeline negotiations, in pipeline reviews, and dealing with pipeline and pipeline issues. A lot of experience. I've had clients enter into hundreds of pipeline agreements all across Pennsylvania, not just in the Northeast, not just in the Southwest, not just North Central, all across Pennsylvania in gas-producing areas, and even some non-gas-producing areas when we're dealing with interstate pipelines running along east to west in the southern part of the state. But with that said, my point is, I believe that I can be an extremely valuable source to a landowner, property owner, considering a pipeline right-of-way agreement. Now, of course, I'm also doing oil and gas representation, so there's certainly interaction and interplay between pipeline right-of-way agreements, lease agreements, and other oil and gas development agreements. One thing, so again, I'm going to reset here. We're going to talk about Sweppy LP. It's a pipeline right-of-way option agreement, holding in my hand right here. And one thing I want to talk about before we go to break is Sweppy LP is a company who also owns leases, who leases property. They're a production company. Drill wells, produce gas when they're not sitting on them for 10 years and no pipelines connected. But anyway, when they actually do something, their idea is they drill and they produce gas. So when they drill and they produce gas, that gas has to go to market. So that gas is going to go to market in pipelines. Now, who is going to install those pipelines? Well, in Sweppy LP's case, Sweppy, I'm going to start calling them just Sweppy. In Sweppy's case, they're going to drill the wells, produce the gas, and then they're going to transport them through pipelines. And in this case, the pipeline agreement is presented by Sweppy LP, the same exact company that's going to do the drilling and own the wells as of this time. So you have a company who's going to produce the gas, then put the gas into pipelines and take it out to market. Well, deductions, post-production costs, all these deductions, what we talk about there are the charges, mostly, that the pipeline company charges the production company. Those charges are most of what we call the post-production expenses, or what we want to try to eliminate as we don't want those charges to be deducted from our royalty payments. So think about this as we go to break. SWEPI is the company that is intending to drill and produce gas, and then SWEPI, the same company, is the company out there asking the landowner around the well, and as the well goes, or as the path goes towards the interstate pipeline, it is SWEPI, the same company producing the gas, seeking the pipeline right-of-way agreements. And if SWEPI doesn't sell either their leases or their pipelines, you have the same company transporting the gas who's producing the gas. So the fees that are going to be charged for pipeline transportation, it would appear that they're going to be charged by SWEPI. And who are they charging those fees to? Well, the other company, same company, called SWEPI. Now a question comes, and I'm not making any judgment, I'm not making any accusations, I'm not. The question, though, becomes, if you have one company producing the gas and that same company transporting their gas and that same company charging themselves for transportation, how much are they going to charge themselves? Are they going to charge themselves higher in exchange, pass those fees on to landowners? I am not saying that they're going to do that, but I'm going to tell you this, that's a big part of the allegation against Chesapeake, that there was an allegation that Chesapeake had a pipeline company. They overcharged. They owned the pipeline company. They entered into contracts with themselves as the producer for very high transportation costs, higher than what the market would be if it was a non-related party transporting the gas. So the allegation, I stress allegation, is that in that case, that the Chesapeake, their affiliate who owned the pipelines, overcharged the gas company, in exchange passed that charge on to the landowners. And since in that case Chesapeake owned the pipeline company, Chesapeake would also ultimately benefit. So here, again, not an accusation, not an allegation, but something to think about. SWEPI intends on producing the gas. They also apparently intend on transporting that gas through pipelines that they own. How much are they going to charge themselves for pipeline transportation fees? And how much of those fees are you going to pay? We need to watch out for that, and you need to ask those questions. Again, this is just something to think about. No allegation, no assertion, not saying that anything is being done improperly or will be. I'm saying, though, it's something we need to think about. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can always give us a call, 570-307-0702. Reviews, consultations, pipeline agreements, multi-unit wells, shut in. If you're shut in, Tioga County shut in for 6, 7, 8 years, I'd like to hear from you, see if we can help you. 570-307-0702. We're going to talk about this SWEPI agreement. We're going to have some fun right after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, join me each and every week at this time on this station for All Things Marcellus. And you can always give us a call, 570-307-0702, regardless of your location. Don't worry about distance. Give us a call. See if we can help you. See if you like what we do, how we do it, and if we can help you, if I can help you, I really want to do so. All right, I'm going to jump into this. I got a lot to cover, and I'm excited about this. I'm really excited. I hope my friend Dawn's listening. Okay, so SWEPI pipeline agreement. Here it is. Pipeline right-of-way option agreement. This is pending out there now. This is being offered now, which is unbelievable to a guy like me who does this every day. This is amazing to me that this agreement is out there and people are signing it. It really makes me sad. It makes me sad because it's a shame in my book, my opinion. All right, here we go. So it's between a landowner and SWEPI for a certain property in Tioga County. States, first paragraph, for in consideration of $300. Remember, this is an option agreement. So they're saying in consideration of $300. So they're going to give you $300 up front for an option. Goes on to acquire an exclusive permanent 50-foot wide right-of-way. So for $300, they're buying the option, the option to install a pipeline within a right-of-way, which is 50 feet wide. So it's their option to do so. Now let's continue. First paragraph. So what can they do in this 50-foot wide right-of-way? Well, it's for the purposes of constructing, installing, maintaining, and operating pipelines. S. Not just one, plural, S. These lines would be for collecting, gathering, and transporting gas, liquids, water, solids, or mixtures thereof. Goes on to say they can also transport water used in or resulting from oil and gas operations. So that means produced water, flowback water, water with chemicals. Goes on. Now, I'm not saying, look, I'm just pointing this out. Goes on. It says, and gas or fluids produced or derived from wells, lands, or other formations not owned or controlled by you, the grantor. So, $300, they have an option. Does not mean they have to do it. They're going to give you $300 for the right to be able to do this in the future should they elect to do so. Should they, what's called, exercise their option and do this. So they're giving you literally $300. I want to stress that. Only $300 to buy these rights to decide whether or not they're going to use them. So, well, here's the question we should all be asking. Well, how long do they have to decide whether or not they will use these rights? Well, let's go here to paragraph number 1. States that grantees shall have the right, but not the obligation, to exercise this option. Goes on to state that they may exercise the option by notifying you, the landowner, in writing and tendering you the right-of-way fees, which they have attached, which I'll go into in a bit, within 5 years from the effective date, meaning, let's just say, the date of the agreement. So, here's the deal. Think about, to me, the craziness of this. They give you $300 today. Then they have literally 5 years to decide whether to use this agreement or not, and to pay you the remaining money, which most people think they're automatically going to get. And it's just simply not true. And then the question is, when are they going to get it? They have 5 years to decide. And during that 5-year time, there are all kinds of restrictions of things you can't do during that time. So you are giving them this very, very powerful right, and we're going to get into it more, very powerful right for 5 years in exchange for $300. $300. By the way, you will pay tax on that money too. $300 to give them 5 years worth of rights for something they may never do. Then in between, you may have other opportunities that come up in year 2, year 3, year 4 that you can't take advantage of because you've signed this type of an agreement. We got to be smart. But unfortunately, we're only in paragraph 1, guys. We're only in paragraph 1. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time for All Things Marcellus, where we bring you the information you need. Not the information the companies want you to know, the information that you need. You need regarding natural gas development. Again, you can always call the office 570-307-0702. So again, we're looking at the SWEPI pipeline right-of-way option agreement, where the company provides you, if you sign this, what I'll call a dog, if you sign this, they'll give you $300, and they have 5 years, the way this is written, to decide whether they're even going to use it. All right. Next, let's go to paragraph 3. Now, I said that you're giving them this right to a 50-foot permanent easement. Remember, though, that's just the introduction paragraph. Let's dive into the meat, the actual grant. What are you giving them? So, number 3 says, paragraph 3, in the event that the grantee, being the company, exercises their option, which, remember, they have 5 years to decide. They're always in a hurry. They're always in a hurry. But they want 5 years to decide. Oh, and then maybe they say, well, we'll move that to 3 or we'll move that to 2. You're always in a hurry. Always in a hurry. You want to get this done right away, but you give me a dang document that says you have 5 years to decide. You must not be in that big of a hurry. Or you give me a document that says 5 years and then you tell me you can reduce it for 3. Or even if you can reduce it for 2. Why are you giving me this for 5 then? Why are you doing it? Because they want to maximize their power, their authority, their rights. They want to maximize their options. And we can't let them do that. You have to protect yourself. All right. So what are you giving them? Paragraph 3. In the event that the company exercises the option, so 5 years, let's pretend they tell you in 5 years, hey, we're going to do this. Now what have you given them? You've given them, quote, they have the right to lay, construct, install, operate, inspect, maintain, repair, replace, abandon, renew, substitute, change the size. They could put the pipeline in the ground, come back, pull it out, put in a bigger line. So they can change the size of and remove a pipeline and associated appurtenances. Think above ground structures, anything above ground, anything that's associated with the pipeline. That appurtenances word is a scary word, which most people have no idea what that means because it's not a word we see every day in our lives. So, going on, says that, so they have these rights with the pipeline and the appurtenances, and then it says, including but not limited to, so meaning they have the rights, including but not limited to, install communication cables, electric lines, buried in the ditch with necessary manholes and splice points at or above ground level. At or above ground level. So things above ground in this 50-foot right-of-way they can have. Goes on. Whether or not the same, meaning the things we're talking about, may be incidental or necessary to their operations. So even if it's incidental, they have the right to do it. Goes on to say, air patrol markers they can put, risers, pig markers, valves, corrosion control equipment. Then it goes on. They also have the right to fence off same. So you can have an above ground facility on your property and with a fence around it. You might not have thought of that when you thought you were agreeing to a pipeline that ran across the middle of your field. Now you got something above ground. It could be 50 feet in width and have a big fence around it in the middle of your field or wherever the heck else it is. So these rights are being granted. There's no disputing this. You're granting these rights, no matter what anyone tells you. These are the rights that you're granting. Goes on. So they have the right to fence off same, meaning these above ground appurtenances, for the purpose of transporting liquids, gases, solids, or mixtures thereof, whether originating in, on, or under your property, or third-party lands, with said pipelines, plural pipelines, and appurtenances, plural appurtenances, meaning unlimited number, whatever they want or need, to be located on the right-of-way. So, as many lines as they can fit and put in that right-of-way, 50-foot wide right-of-way. As many lines and as many above-ground structures or below-ground structures, appurtenances, cables, communication equipment, as much as they want or need that's necessary or even incidental. This type of an agreement allows those things. The good news is you can limit this in almost every case. The bad news is many people either don't know that or aren't doing it and are giving the company an unbelievable amount of rights when they don't need to do it. And in this case, they are doing it at such a disturbingly low compensation value. I guess I'll leave it at that. At a very disturbingly low compensation value. My opinion, not specific advice in any of this, my opinion, but boy, do I believe it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So, okay, I'm going to break this one off here because I got a bunch more to get to. I got a lot more to get to. Let me just summarize. This agreement says we'll give you $300. We have 5 years to decide if we're going to use this agreement, install any pipelines. And then during that 5 years, if they decide to use this, they'll let you know. And now they have all the other rights that we just talked about. Unlimited amount of pipelines, unlimited amount of above ground facilities, which they can fence in if needed. Now, I'm not going to say they're going to build like a 50-foot wide, 2,000-foot long building or structure. But the idea is there's no limitations to the amount of structures, facilities that they can have under or above this 50-foot wide path that goes across your property. That's pretty darned powerful. And again, we really need to negotiate to limit these, and I believe you can. And I'll jump ahead for 1 second for this punchline. Remember, but we're going to really beat it up because there's a lot more to say. But remember this. They give you $300, then in 5 years they decide if they're going to use the right-of-way, and when that happens, they have to notify you and send you the remainder payment. Well, that payment's typically going to be the big payment. So the per-foot price in this case in Tioga with a current offer. Now, please, if you're offered higher than this with SWEPI and Tioga, don't get excited and think, oh, I'm offered $15. That's fantastic. Where do I sign? Please don't do that. Please think, and again, it's not specific advice, but my point is please think about it. Please think about what you're doing and get information. This particular case, if they exercise the option, it hurts me to say, seven, the number between 6 and 8, $7 per foot compensation. $7. Remember, we aren't in the 1980s. My opinion, and my strong opinion, $7 per foot to me is laughable, but it's not funny. It is not funny at all. $7 per foot is an unbelievable joke to me, in my opinion. Again, people may feel differently, but I do pipeline agreements all the time, and we have clients that sign them all the time. And routinely, the lowest, in many areas, we start at $30 a foot. And many times we negotiate $30 a foot to considerably higher compensation. And we limit in many cases to one pipeline only. And in other cases, we get many cases $50, $100 a foot. Cases where they're ranging into the $1,000 a foot range in certain circumstances. But you don't know what you have until you find out. And so we got to put the pens down and we got to pick up the phones. And we got to understand what we have. And you can always do review consultation. Give us a call, 570-307-0702. Remember, this isn't specific advice for anyone saying don't do this, don't do that. What I'm saying is don't sign bad agreements. Pick up the phone, call, get assistance, do a review consultation, whether with me or someone else. But man, $7 a foot, in my opinion, is a joke. And gosh, people signing that just breaks my heart. It really does, because I have clients routinely signing 4, 5, 6, 7 times that amount routinely. And we got people in Tioga being, in my opinion, taken advantage of. And we have to stop it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give us a call, but no matter what, keep listening. Join me each and every week at this time on this station. There's, of course, and unfortunately, more bad to talk about. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each and every week at this time on this station for All Things Marcellus. And you can always call the office. You want to learn about reviews, consultations, representation. Remember, I have not, I do not, and I will not represent gas or pipeline companies. Give us a call regardless of your location. I have clients all across Pennsylvania in gas producing regions. Have clients who live all across, or have had Clients live in many different areas in the country who have property rights or gas rights in Pennsylvania. So give us a call. See if you like what you hear. See if we can help you. Reviews and consultations are often a great way to start. And then if you need further services or you want further services, we can go from there. But, you usually, depending upon the matter, usually reviews and consultations take an hour or two, including doing my preparation, research, preparing, reading the documents you provide me, and are either in office meeting or a conference call. And I can join in people. We join in relatives from different areas of the state in the same call. So it's been really a valuable service. And I know I preach it a lot, and I do because I believe in it. I really believe in it. And I know it's helped so many people. So if you're given any agreement, think pipeline, any agreement, but we're talking pipelines today. I have to say multi-unit well consents. Multi-unit well consent. Put down the paper, pick up the phone. I think we can help you. So I want to stress that also. And then finally, real quick, we're talking about SWEPI. We're talking about pipeline right-of-ways. But remember, if you're in Tioga County and you've been shut in, especially 7-8 years or more, and you're shut in and you're just getting annual shut-in payments, I want to hear from you. I want to see if we can help you. As I say, it's wrong and we need to do something about it. That's my opinion. So I want to hear from you at 570-307-0702. Okay. Back to the SWEPI LP pipeline right-of-way option agreement that's currently pending in Tioga County for at least one landowner, and I'm sure many others. So remember, they're going to give you $300 up front, $300, which would be my understanding, it would be taxable. So you're going to pay taxes on $300. You're going to give the company, SWEPI, the right to decide within 5 years whether they want to use this agreement. And then if they use this agreement, if they notify you in 5 years from now, they want to use it. And I'm going to talk more about money at the end. They're going to pay you a blistering $7 per linear foot before laying the first pipeline on the right-of-way. $7 per foot. It's amazing. All right. I'm going to do that now. All right. Moving on. Pipeline right-of-way option agreement. Paragraph number 3. Letter B, as in boy, have the right. So company, SWEPI LP, should have the right, if they exercise the option, at any time. So they can pay you in 5 years and wait another 20 years or another 5 years or 1 year or whenever. They have the right at any time or times to lay additional pipelines and appurtenances and to operate, inspect, maintain, repair, replace, renew, substitute, change the size of, and remove all pipelines and appurtenances built on or under the right-of-way. So again, remember, they can put as many pipelines as they can fit into this 50-foot wide area. They could come back, in theory, every 2 years and install another pipeline until they couldn't install anymore. Now, they're not going to do that, but they sure as heck may come back and install 3, 4, 5 pipelines. There are pipeline agreements that I will do and represent clients that we agree to, but they are negotiated and they're done very carefully, but may allow even 4 or 5 pipelines. 4 pipelines, I've done many agreements that allow for 4 pipelines, but we put in limitations, parameters, time frames when they can be installed. Maybe the company has 2 construction opportunities, meaning that they can construct or install pipelines on 2 different occasions, and the most that they can put in is 4. So they could put in 3 at once and 1 at once, or if they put in 1 the first time and 1 the second time, no more pipeline rights. That's just a sample. Many things you can do. These things need to be negotiated. But this right here opens up this property. The way this is written, open up any property that signs this to an unlimited number of lines and to have above ground facilities wherever they want. And oh, by the way, remember, they can have cables They can have electric lines, communication cables, manholes. It's pretty darned broad. And unfortunately, and as often is the case, it just is going to get worse. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We're walking through this SWEPI LP pipeline right-of-way option agreement presented currently to landowners in Tioga County. So next, remember we are in paragraph 3. Now we'll go to 3C. That was 3B, now 3C. SWEPI has the right to ingress and egress. That means travel to and from, in, on, and over, and across the property, and adjoining lands owned by you. So, if you are giving a right-of-way on a piece of property you own, and you own other property that adjoins it, you've now given the company the ability to travel over and across your other property, as well as the property with the pipeline right-of-way agreement. So you would notice too, it says, well, it goes on, it says, that this is for any and all purposes necessary and convenient to the exercise of their rights of way, and easements granted herein. So now they can go anywhere they want across the property to and from the right of way if it's necessary or convenient, or necessary and convenient, I'm sorry. Now, subsection D, the company also has the right to use temporary workspace, this is important, of an additional 50 feet in width adjacent to and along the right of way. So that means you have a permanent width of 50 feet, and that's a permanent. That's what the company is essentially, think of it as they're buying that forever, and whatever they can put in that area, like we talked about, they can put in that permanent easement. As many pipelines, as many above ground structures as they need, they can put into that permanent 50-foot area. But then they have an additional 50 feet, so it's a total width then of 100 feet. So that additional width of 50 feet they can operate, use to install, use to maintain their pipeline. So they have an additional 50 foot of temporary workspace alongside the pipeline, the permanent space. But in this case, there's no discussion regarding, or no reference regarding, does that temporary workspace expire? How long did they have that 50 foot extra to make it 100 feet? Is that forever? Or does it expire in a year? And again, those are things that can be negotiated to establish what exactly that means, that they have an additional temporary workspace of 50 feet. Again, too, companies will tend to clear. If you have timber and you think, oh, I'm agreeing to a 50-foot right-of-way. Well, no, you're agreeing to a 50-foot permanent and a 50-foot temporary right-of-way. So the company is going to, in most cases, clear 100 feet wide, or width of 100 foot through the property so they can use those areas. Generally speaking, that's what's going to occur. But then we have one more part of this same exact sentence. And if you're following along at home, we're in 3D as in dog. So they have a temporary workspace of an additional 50 feet. Now listen to this one, guys. This is a big loophole. Together with the right to use additional temporary workspace on the property as needed. Well, who's going to determine what they need? They are. What are you going to do? Sue them after the fact? You're going to go into court to fight this? So they have 50-foot permanent, 50-foot temporary, then an additional temporary workspace on the property as needed during the exercise of any of the rights and easements herein granted. So they have an additional unlimited amount of workspace as they need it. So who knows what that is? And do you want to be fighting about that later, or do you just want to see it happen and do nothing about it and say, geez, I didn't know that could happen? So you need to eliminate that workspace. You need to define where they can operate, and you try to minimize the size of the easement, but you need to solidify exactly where they can operate. Surprises are bad. We don't want to be surprised. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Okay, we're going to hit one more section here. Section 3F. So again, this is every one of these so far. A, B, C, D, E, F. Actually, I'm on E. I'm sorry. We will do F also. All right, 3E. The company also has the right to construct, open, gravel, repair, improve, maintain, and use temporary access roads for ingress and egress, meaning travel to and from, its oil and gas operations. What? Wait a second. What? Remember, this is an agreement between you and Sweppy LP, the company who also is a good chance producing this gas or your gas or gas in this area. This doesn't say to and from their easement. This does not say to and from their easement. This says, quote, to E, that they have the right to construct, remember that, meaning create, construct, open, gravel, repair, improve, maintain, and use, so they can construct and use temporary access roads for ingress and egress to and from its oil and or gas operations. What does that mean? What does that mean? What does that mean? This is a pipeline right-of-way agreement with Sweppy LP. Sweppy LP also may be the producing gas company, and you're signing a pipeline right-of-way agreement that says, in this agreement, subsection 3, letter E, you're agreeing that the company has the right to construct, open, gravel, repair, improve, maintain, and use temporary access roads for ingress and egress to and from oil and gas operations. Not to and from the easement that you're granting herein, to and from oil and gas operations. That must be addressed. That must be addressed. Remember, right above in subsection 3C of this same right-of-way document, it says that the company has the right of ingress and egress through the property and other property that you own that adjoins your property for, and here's what this one is. This is what this ingress egress right is. For any and all purposes necessary and convenient to the exercise of the rights, right-of-way, and easements herein granted. So it's tied to what you're giving them. So they can go to and from this pipeline easement. But 2 paragraphs later, in 3E, it says that the company has the right to construct, open, gravel, repair, improve, maintain, and use temporary access roads for ingress and egress to and from its oil and gas operations. What operations? Where are they? That is crazy, guys. Crazy, and has to get out of there. I'm up against it. You're listening to All Things, but we're not done. We're not done. We got one more segment to go, and we got a lot more shows to do because I'm sure as heck not done with this. They're going to have to drag me out of here. You're listening to All Things Marcellus with Attorney Doug Clark. Join me each and every week at this time on this station. One more segment. Give us a call. See if we can help you. 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Short on time this segment, so let's get right at it. We're talking about the Sweppy LP pipeline. I don't care where you are, you get a pipeline agreement. My opinion, put down the pen, pick up the phone, whether you call me, call somebody. These things can be negotiated and often negotiated significantly to your benefit, and we have to do it. So I want to point out some other things, and unfortunately, there's just not enough time in the show. But let's talk. So we go on. Next item is subsection 3F. The company has the right to leave on the property in wooded areas adjacent to the right-of-way all chips and stumps created by the removal of timber located on the property. I went one time to a client. I saw a stump pile that was 20-some feet long. Boy, when I was a kid, I would have dreamt to come across a stump pile like that. Hopefully, who knows how hurt I might have gotten, but I would have loved that as a kid growing up in the country. That would be a dream come true. So these guys are just going to throw and pile stumps anywhere the heck they want in wooded areas along the right-of-way, which it could take decades for these stumps and this other material and chips to decay and rot. Like that's, no, you want that stuff chipped, hauled away, spread around. This is crazy. Again, crazy. Very cheap for them. This is amazing. Cheap for them as they pay $7 a foot. All right, let me go on. Next, I want to go to H. It says that they'll bury the pipeline at 36 inches below the surface where reasonably possible. Well, that does you a whole heck of a lot. Then, and this is unbelievably disturbing, couched in here after the burying of these pipelines of 36 inches, where reasonably possible. Who knows what that is, but that's what you're agreeing to. But here's something else that's really problematic, and I mean potentially enormously problematic. Farmers and others, notwithstanding the foregoing, meaning despite everything above, grantees shall not be required to bury temporary water lines that are laid upon the surface of the property for less than 180 consecutive days. So what does that mean? 180 days, 6 months. They can put above ground water lines across this easement. So it could be across your entire property. Sometimes it goes right through the center of fields, right through the center of your property. Think fire hoses. They can lay there for 6 months. You don't get a dime. You don't get a dime. This is all included in their $7 per foot, which again is a joke. It's a joke in my mind at $15 a foot. Start talking $30 a foot, and now you're, in my opinion, you're at a real market price. They're talking about $7 a foot. So year after year, you could see above ground water lines going through your hayfield, your cornfield, whatever else, wherever this easement is. And you can see potential problems with this water line. They're going to be on the property, laying it down, picking it up. They could be laying it down, picking it up every year. Unlimited number. They just can't, if it's going to be, they have to make sure that if it's above ground, it can't stay there for more than 6 months. They could pick it up for a month and then come and put it back. But it just can't sit there for 7 months straight or 6 months in a day straight. That's a really bad provision. I got another client right now with a temporary above ground water line pending agreement. That's a standard offer just shy of $7 a foot. And so again, let me just explain that. Above ground water line client currently offered by a different company in, I believe it's in Bradford County, $7 a foot. So just under $6, I think it's $6.88 a foot. And this is temporary for one time only. And these guys want to pay you $7 a foot, put as many lines as they possibly can bury, have the right to put as many lines as they can bury in the right-of-way, have the right to put as many things above ground in the area of the right-of-way, have the right to lay water lines as many times as they want forever across this area, as long as those water lines don't stay there for more than 6 months. And now, the pay terms. So here it is, Exhibit B, payment and damages. They're going to pay you $7 right-of-way fee, $7 per linear foot before laying the first pipeline. Then it says that they will also pay you marketable timber, depending upon the value at harvest. They would pay you damages for crops upon the removal of any growing crops. So if you have crop loss for the next few years, you're on your own. Temporary access roads. Sit down, because this is going to be a big number. They'll pay you $1.50 per foot. So you have 1,000-foot long access road on your property, temporary access road, and they give you $1,500. Remember, you're going to pay taxes on that. Then they got to clean it up. What kind of mess is that going to leave? Maybe none. Maybe a problem. Workspace. They'll pay you $800 an acre. Let me just tell you, in my opinion, that these numbers are just unbelievably low. Then for the pipeline appurtenances, these above ground structures, $2,500 per unit. They even say per unit that they would pay on installation. There's no limit to this. Again, guys, I'm sorry, but in my opinion, this is crazy. All right, it's a short segment. I'm against it. Join me each and every week for All Things Marcellus at this time on this station. Give us a call, see if we can help you. 570-307-0702, 307-0702. Remember, I have not, do not, and will not work for an oil and gas company. Landman works for the company, not you, the landowner. Put down the pen, pick up the phone, and have a great, great week, everyone.